So guys, thank you very much. Wonderful job. To the folks in the audience who are watching, the folks from the Bureau of Engraving and Printing here did a lot of preparation to prepare for this. And if you go online and you look at the cases, what you'll find is the information that's given both to industry and contracting folks that are actually playing the role in these mock debriefings isn't complete. And it isn't complete to kind of get us focused in on specific topics. So keep that in mind as we engage. So I wanted to ask you a couple questions. I'm wondering kind of what are your thoughts on what you just went through? To talk maybe about some things you learned in preparation, some things that you were frustrated with. Did you feel that industry kind of understood what you were trying to relay to them? Were there any kind of communication gaps? Anything that you want to highlight about what you just went through?
One of the things that we did in preparation, we felt very compelled. The lack of information was very frustrating. So we decided to go into, I figured that at some given point, something of this mass have happened in the past. So I went into FBO and just kind of figure out somehow, the United States Coast Guard had bought HC-130. So I Googled it, and there it was. There was an announcement, and there was an award back in 2013. And then I said to myself, this must have made it to the Government Accountability Office. And there it was, the GAO decision. And so we did some research and just kind of read as to the actual case, which it was a variation of the scenario in itself.
Yeah, it is different. Certainly different, but
just kind of, then we decided to kind of get more into the weeds of what happened in the real case and just read more into past performance, what's allowable, what's not allowable, trade-offs. We ran into price realism and kind of did more than we needed to.
It sounds like as a team you spent a lot of time engaging on this to kind of prepare for this discussion.
We did a lot of time we spent a lot of time individually reading through the materials and understanding and dissecting the information before we came together. Mm-hmm. We also did research, as Millie stated, online. And we also, my approach is always, you always take it back to the FAR. Mm-hmm.
Right.
What does the FAR say that you must do? What can we do? What is not permissible? The FAR is always the basis from my perspective, and that was our approach in how we outlined our debriefing, and then just kind of worked within the framework of that, and then incorporated other research that we felt was going to be useful.
And whatever wasn't in the FAR, we did more research. Just because it's not in the FAR doesn't mean that you're not allowed to do it. So there's some innovation and some other stuff that you can do. So we did more research into that and what's more permissible and what had happened on GAO cases that we can kind of reach into it.
Mm-hmm. Mm-hmm. One of the concerns that I had was that the past performance questionnaires did not go into. There was adverse information on the past performance questionnaires. And I thought originally that we had to have talked to the offeror and asked them to give them an opportunity to respond. And I learned from reading GAO cases on this that you do not have to do that if you are not holding discussions with them, which we did not hold discussions with them, so we did not have to do that.
We spent a lot of time as a group trying not to.
That also came out in our discussion, and so when we met as a group, we agreed on some things we didn't agree on, and so that came out in discussion, and Doug still wasn't quite convinced, and when he went and looked on GAO, he came back and said, you guys are actually correct. We did not hold discussions, and we award without discussions. We reserved that right in the solicitation, and so there was nothing we received that was adverse that would raise any type of concern that would require us to go back. So we debated each other a lot.
We thought about a lot of what-if scenarios.
So one of the things in the opening remarks to this is, you have to teach contracting officers to think and acquisition professionals to think more holistically about their job. And historically, training has been Con 100, Con 200, program management, and you learn about a specific silo. And so the goal of this case was to actually force you to go and do that research, to force you to go through what-if scenarios, to give you haphazard information that would make you feel very stressed, so that you would kind of cognitively think holistically about this and come up with a way to deal with it. So I'm really excited to hear that you did that, because that is like the whole purpose. If you're training people to think, you put them in this situation. If you're training people to check off a checklist, you send them to COD 100 and teach them every single rule that's in the FAR related to FAR 15 or FAR party.
One thing I learned yesterday from Joy is the word we can agree to disagree. And so it was actually we learned a lot from each other, and that was very, very useful.
We did get a little emotional talking about it.
Yes.
You know, it was, like because of the stress and the limited information. We were getting ourselves worked up on it. But I mean, even with it being a mock debrief.
There were some things that internally we disagreed on whether they could be divulged or not, but we came to a consensus, and even though there were dissenters,
that was a lot of the discussion.
We agreed to hold the party line on certain items.
Right.
That's good.
It was very important, especially being the contracting officer in the scenario that
we're going to support you.
But
not that I was just supported, but the government, this is our position, this is the reason, and here are certain things where this is what we can say, this is what we cannot and will not say, and things that we should stay away from. And that really proved to be helpful. And it would keeping us on one accord.
It would also be if you were doing this in real life with other corps who may not be as well versed in 1102 rules, contract specialist rules, it would be helpful to talk with the corps beforehand to make sure they know other things, like, for example, if something was not in the evaluation, then you should not be talking about evaluating it at the debriefing, because sometimes you can have someone who might speak out of turn and say something that they shouldn't, and cause either a miscommunication or something worse.
Before I turn it over to Thomas, one other question. The other goal of this was to put you in a no-risk environment. I mean, there's a little bit of risk with the camera, but a no-risk environment where you could actually engage with industry. I mean, we've talked to people who are acquisition professionals who the first time they engage with industry in a debriefing is during the debriefing. I mean, they got the rules in a class, but they never had the experience. Do you think that it was helpful to actually have the experience with real industry professionals?
Oh, yes. It's actually, it's a very different environment. A lot of the times we're just talking about that. We do it on ourselves, 1102s, to 1102s, and we all have our knowledge of how the regulations are supposed to work. But industry standard, they have different rules. And so their goal is make profit and make my company better. And so we also have to be cognizant of that and understand where they're coming from. And so their professionalism, the overview of what they're thinking, just the fact that they went above the scope and they were thinking 15 years ahead. And I'm like, wait a minute, that's not, we have bona fide of now, and this is what we're looking for. And so there are a lot of things that came across that I was like, I didn't think that they would spend that much energy in thinking why would make you feel that you're entitled to a contract for 15 years. But yes, it was very, very...
One observation we were talking about this as we were preparing, like we've done these kind of mock debriefings in classroom environments before amongst government personnel, like playing the role of a contractor. And it never fails. We've all had the same experience where the government personnel playing the role of the contractor are adversarial and and they're coming at the government personnel and that was not the experience at all. And I think in most real world scenarios, you don't have that kind of interaction. And so it was nice. I mean, they certainly were obviously on their game, and but we can learn a lot from. Like, look, it's a conversation. It's a learning opportunity for us as well. As government personnel, like in a debriefing, it's not just for them to learn. We have to take away stuff as well. So anyway, I thought it was a good back and forth.
Thomas, did you?
And I, one of the questions I thought I would like to ask is that during the debriefing scenario here, we noticed there was a lot of discussion on the pricing, and they try to tie it back in their technical approach. Did you kind of discuss maybe beforehand, just simply saying, you did have a superior technical approach, but by the way, this is our price and your price was this, and too bad. Yeah.
Disclosing the government's.
You just had a simply, your price was too high.
And basically said that maybe we could have come back and just been more direct and said their price is too high. But at this phase in the debriefing, it's our position is it was not appropriate to disclose the government's IGCE, and that's why we did not.
Yeah, and also I think based on the information I have, I might be wrong, but I think all three proposals were found to be fair and reasonable in their pricing. Obviously theirs was higher, but I don't know that we would have just want a blanket say, no, your price was higher, so we're not going with you. When all of our evaluation criteria was leaning toward, price is certainly an evaluative factor, but it's not the most important. And that would I think that would maybe leave them with that feeling like, well, what do you mean? It ultimately just came back to price. But.
And they knew their price was too high. Us reiterating 13.9 million, that's a significant difference. We didn't just use percentages, we crunched numbers. That is a huge difference in when you're trading off, determining is it really the value that they're going to provide to the government, is it really worth an additional $14 million? And in this case, given with the facts and the evaluation results and the source selection authority, we just did not have the information we felt we needed to justify paying that additional $14 million. And yet, if you take a step back, even think about it in the real world, a real life situation, me as a CEO, I'm still going to have major concern with going back and trying to find $14 additional million when I know there's another proposed solution that also was technically acceptable. That's just not, in my opinion, sound business judgment. We are the gatekeepers of taxpayer dollars, and I feel like with the limited information that we had, if we had more facts, maybe I wouldn't have done $14 million, but perhaps.
And that's
we could have opened
we
up,
discussed,
but
yeah.
we decided to award without discussions. So we had to make a decision based on the information that was provided. But perhaps we could have opened up for maybe clarification and go back to the offers on some things as it pertains to price. But we did not in this case.
It's a good answer. And the whole purpose of the case was to generate thought process there, and for you to have to make a decision on that. So I'm so happy that you got to that point and had a robust discussion around that. You have any other questions? Guys, I thought you did a wonderful job. And if we put any undue stress on you yesterday, it was on purpose. So good work.
Thank you.